Good afternoon, everyone, and good morning or good afternoon for those of you watching on the webcast. Thank you for joining us today for a very important topic for this business hour, what your business needs to know about Chinese intellectual property. My name is Dave Kupar. I'm the co-chair of the McDonald Hopkins Intellectual Property Group. And with me on the panel today to discuss this topic is from left to right. To my left over here is Ari Sherwin. Ari is an intellectual property attorney at the Sherwin-Williams Company, located here in Cleveland, Ohio. Ari leads, from an IP perspective, Sherwin's largest division and counsels Sherwin-Williams on a number of international intellectual property management and enforcement issues, including in China, which is, of course, the topic of our conversation today. To my near left is Todd Benny. Todd's a member here at McDonald Hopkins, and he's a part of our intellectual property practice. He focuses his practice on IP portfolio management and counseling. Todd was previously the in-house intellectual property counsel at Office Depot in Florida, and has handles numerous IP strategy issues in the country of China, including in trademark, patent prosecution, and other type of enforcement type issues as well. To my immediate right is Grant Monachino. Grant's a member here at McDonald Hopkins and is a trademark attorney who specifically handles international trademark portfolio strategies. He assists clients in with large sophisticated portfolios around the world in developing strategies on how to protect those marks in a number of different countries. Grant has specific knowledge and depth in dealing with Asian intellectual property issues, particularly in China, for a group of very large clients. So has, again, a specific amount and a large amount of experience there. And then finally, to my far right here is Dr. Shenmin Yin. Shenmin is a patent and trademark attorney at Beyond Attorneys at Law, which is located in Beijing, China. Shenmin actually practices, however, here in the United States, and she heads up the New York City office for that firm. She spends her time both in China as well as in the United States, handling both US-based clients as well as Chinese-based clients on Chinese intellectual property matters. Shenmin has her PhD in cancer biology from the University of Texas, and her technical area specifically is chemical, biotechnology, and mechanical, specifically the medical device arts. So starting with you, Ari, I want to talk to you about the following. We know at a general level that intellectual property has become such a huge issue in China. Let us know what this specifically on how such protection is important to US-based companies such as Sherwin-Williams there.
Sure. China is undoubtedly the world's fastest growing economy, with an average growth rate right now of about 10% per year for the past 30 years, which is incredible. China is expected to surpass Japan as the second richest country in the world. It probably would be the richest if the United States paid them the money that we owe, but that's not going to happen. That being said, China is still the world leader in exporting, the second in the world in terms of importing, so obviously it plays a huge role with respect to Sherwin-Williams and other similarly situated companies. And that's why we take proactive steps in terms of solidifying our IP portfolio in China, be it in the form of a patent, trademark, copyright, and also leveraging that IP to bolster our portfolios elsewhere, be it in the United States or countries around the world.
Yeah, and before I go any further, especially with the discussion we're having here, if anybody in the audience here, either in person or on the webcast, has questions, for the people in the audience here, you'll have a card in front of you. Please write them down and hand them off to the side. Or otherwise, if you're on the webcast, please type them in and we'll receive them in real time. We'll do our best to answer them during the hour. If, however, we don't get to them, we'll do our best to reach out to you directly afterwards here in the room, or we'll reach out to you by email or with a phone call if you're outside of the room here. Going back, Ari, now in terms of Sherwin's involvement in China and how that's reflective of a number of U.S. companies nowadays there, how has IP law in China changed the past decade?
The law has changed dramatically. Just to give you an idea, in terms of patent filings, China is now the leading nation on earth in terms of filings in China, surpassing the United States with just last year alone filing 2 million applications. Regarding trademarks, last year they led the world with 1.6 million filings. And just for comparison's sake, the United States had just over 400,000 filings there. But if you take a step back, the change has been monumental because it was only 15, 20 years ago when China was trying to attract foreign investors, foreign companies to bolster their economy, and laws were a lot more lax then. And also the Chinese nationals were not familiar with the intricacies involved with patent and trademark protection. They weren't really familiar with formulating litigation strategies. But then over time, they decided to, through implementing their National Intellectual Property Strategy program, promote indigenous innovation. And their practitioners, their technology has really gotten better throughout the past 10 to 15 years.
Has that affected Sherwin's business based off of that change in business philosophy within China?
Absolutely. We just ensure that our agreements and technology is really set in stone before we start partnering up with business vendors in China, be it suppliers, tolling manufacturing sites, protecting our technology in the US in terms of trade secrets before that's shared with a Chinese entity, and vice versa.
Now, Shenman, Ari mentioned that we had last year in China over 2 million patent applications filed, 1.6 million trademark applications filed. Are those filings from Chinese, mostly Chinese entities or non-Chinese entities?
Yeah, so most filings are still from Chinese applicants. So here I have a data to show last year CIPO received 2 million patent applications, and 1.9 million applications were filed by Chinese applicants. So another data also shows, there were 600,000 invention applications before Chinese Patent Office, and 80% of the invention patent application were filed by Chinese applicants, 18% by foreign applicants. And I think that this is the same situation for trademark side.
Why do you see so many filings by Chinese entities in China, both for patents as well as trademarks?
I think that there are several reasons for the big number of filing increase. So first of all, the IP protection now is very important for Chinese company. So they try to switch from the manufacturing industry to the invention, industry. So Chinese company realize the importance of the IP protection. Another reason is the Chinese government actually try to promote the filing numbers by some funding policies. So central government, local government have different kind of the funding policy. So if you file the PCT application, for example, you will receive 50,000 yuan for the filing. And if you nationalize in 5 countries, each country you will receive the 100,000 yuan. So totally it's around $80,000. So that covers 5 countries and PCT nationalization.
So you see this incentivization by the Chinese government for its companies internally to file more trademarks and patents. How about externally? Are these Chinese companies also seeking IP protection outside of China?
Yeah, so because of the Chinese companies realize the importance of the IP rights, so they are willing to filing a lot of the applications overseas. So I also have a data that shows, first of all, the PCT application filing. Now China is #1 filers, just behind the German, a few hundred, application. And another one, I have some Chinese in-house survey data. They survey, ask the Chinese in-house about several questions for IP protection overseas. And one question is about, has your budget for filing IP overseas increased over last year? So 85% of the Chinese in-house said yes. And another question is about how many cases are going to file outside of China. 80% of the Chinese in-house said they will file the numbers will be between 50 and 2% of Chinese in-house said they will file over 500, and another 10% of the Chinese in-house they will file over 100, between 100 and 500.
And that's just outside of China.
Yes.
Yeah. So obviously, Chinese companies are filing in significant numbers both inside of China and more aggressively filing outside of China. Todd, in terms of what you do with counseling specifically U.S. companies when they enter into the Chinese market or seek IP protection in China, specifically from the patent side, what should U.S. companies keep in mind when they enter into China about differences between U.S. patent law as well as Chinese patent law?
Hey, Steve. The first difference is that in China they have this utility model, which is different than what the U.S. has. The U.S. doesn't have anything that corresponds to that. And basically, it's very similar to what we would consider a utility patent, except for the fact it's not actually examined for patentability. You file it, they will examine it for certain particulars just to make sure that the form and function of it meets their requirements, but then it issues. And it will issue in probably 3 to 12 months on the outside. So it's a very quick way to get IP protection in China. To give you some examples, they filed in 2012, there were 740,000 of these applications actually filed in China. Of that 740,000, only 5,800 were from foreign entities, and of those 5,800, only 546 were U.S. companies. So it's something that U.S. companies are not taking advantage of. And I think the primary driver is we don't have anything that corresponds to that in the United States. So it's a big distinction, and that U.S. companies need to recognize that when the situation arises, that this is available to them and they can get intellectual property protection very quickly, much quicker than you could ever get in the United States.
So basically, you have two types of protection in the U.S., right? Design patent protection and utility patent protection, and there's 3 types. So can you explain through, just to be clear, what the 3 types are in China then?
So in China, they also have what they call an invention patent, which is what would correspond to our utility patent. It's very similar requirements. I would say the biggest distinction there is that in U.S. law, we rely upon our drawings very much to garner support for claim amendments, whereas in China, this is much more like the European practice, where they don't look to drawings. They want to see the exact language in the specification. So when you're making claim amendments, it's important to consider that when doing it in China. Design patents are very similar to the U.S. design patents, except they don't recognize phantoming. So they want to look for the full line drawings of their products. And when you do an infringement analysis, unlike the U.S., they want to see your product. They actually want to make sure that your product is covered by your patent before they'll really do even an infringement analysis. So that's another distinction between them.
One thing that is interesting about this entire topic regarding China is a number of us here on this panel have done these business hours or roundtables before, and we typically get a lot of questions during the discussion, as you might imagine. This one, we've got a lot of questions beforehand, which blew me away, and it shows how important this topic is. And so one of the questions that we received that goes right to this point, and here it is, that we received is 80% of all the patents granted in China in 2012 went to domestic inventors, while U.S. inventors were granted less than protection in China less than 50% of the time. Should U.S. inventors and companies expect this to improve over the next few years? Before you go there, I'll sort of say this. I think the question's even broader than that, I think, and you see this with clients, which is, are we getting fair treatment in China? Is the playing field level for us when we walk into the Chinese market as it would be for a Chinese entity? What's your thought based on those numbers? How do you read those numbers based on your experience?
Well, I think I'll start with, is it fair treatment? I think for the most part it is. The Chinese government recognizes that they need this investment in the Chinese market to really make their economy grow. And if they don't get this, then the economy is not going to grow. They need this foreign investment. I think probably one of the primary drivers for the distinction between the percentages is that when U.S. companies file their the patents in China, they're filing more or less their U.S. corresponding patents. And we just have a different practice than they do, than the Chinese requirements. So you've got to be aware of that. And when you're drafting your patent application, you want to be sure that you provide a very broad specification that includes all the embodiments that you potentially want to cover. Make sure that you're not going to rely upon your drawings solely, because if that's the case, then you're going to have trouble getting that allowed in China, especially when it comes time to make claim amendments. They're looking for almost the exact word-for-word language from your specification when you make the claim amendments. So it's important that you provide this kind of language in your specification when you draft the patent applications. And I think if you do that, you'll see that percentage get back to almost even.
And do you think that percentage will increase too as U.S. companies get to know more about the utility model patent system and file that, and going that route with their filings more often? I
think they will. It's sort of this great kept secret from U.S. companies that they're not taking advantage of. And I have a couple statistics here that are interesting. Is that from 2002 to 2012, 52.6% of utility models were found to be valid in court proceedings, whereas the invention patents, that number was 58.14%. So there's that perception, I think, in the U.S. that utility models are not as sophisticated as invention patents. Well, that's not necessarily true. At least the statistics hold out. I mean, it's a 6% difference, which is not a huge difference. So it's definitely has a great opportunity for U.S. companies. And in fact, there was one Chinese case of note that a Chinese company actually sued a French company and got an award of $53 million US on a utility model. Now recognize this is an unprosecuted patent application, and they got $53 million. They ended up negotiating it down to $25 million. But it's a really powerful tool that U.S. companies are not taking advantage of. And if you're in a market, especially what I call sort of the speed markets, electronics, things like that, where technology is changing drastically and very quickly, and your technology is obsolete so quick, this is a great opportunity to get some protection very quickly.
And Shenman, going to you, obviously Todd raised this issue of not only do a number of companies in China file for these utility model patents, but also identified some teeth there. I mean, a $40 million verdict on a utility model patent definitely, for the people in here involved with patents, definitely gets their attention. How do you counsel U.S.-based clients on utility model patents? Do you believe they're a good idea at least for consideration for U.S. companies? And what are the pros and cons versus other types of protection U.S. companies can receive in China?
Okay. Yeah, so utility model patents is very unique in China and also very powerful tools for Chinese company. So if you have very important product in China, want to get protected in China, so one thing you can do, you can file both at the same time. You can file invention application, utility model application at the same time, and you get the patent granted very quickly. And then when the invention patent is ready to issue, you can give up the utility model patents, and you get the invention patents granted. So that's a very useful strategy for covering the important product. And also the cost is only 25% more than filing invention application alone, because you just need one translation. So translation is a big part of the cost. But you cannot file both through PCT application. PCT, you only can file it through the Paris Convention within 12 months priority.
Can you explain too how long of protection it is between utility model versus a utility?
Utility is 10 years. 10 years from the filing date. Invention is 20 years from the filing date.
So twice as long.
Twice as long, yeah. And also one thing is for utility model. So Todd mentioned the invalidation data shows they kind of similar. So that's because the level of the invented step for utility model patents is relatively lower than the invention patents. So that's when you challenge the utility model patents, the prior art in the same technology area, and only one or two prior art can be used together to challenge the inventive step of utility model patents. So that's the reason why they are utility model patents, it's easier to face the invalidation challenge.
Thanks, Shem. I want to turn our attention now a little bit over to another direction. I want to talk about trademark protection strategies. And Grant, turning over to that portion now, how do you counsel U.S. companies in protecting their marks in China?
I'll get to that in a minute, but to answer the question to some extent about the fairness, I think sometimes there's a perception of unfairness because maybe the expectation of a client is that things might be similar in China than they are in the U.S. I think when U.S. clients understand that there are these differences and that the landscape is a little bit different at times, that expectation changes, and they feel like the results are fair in the sense of the rules in which they're playing in China. But to get to the trademark protection strategies, I would say the fundamental protection strategies are sort of basic in that you register your marks, you record them with customs if you're concerned about counterfeits, and you have a manageable enforcement strategy that fits your company. And it's sort of the obvious, but registering your trademarks is the best offense and the best defense. Without having a trademark right recognized in China, it's difficult to enforce. And so the easiest way to do that is through a trademark registration. On the flip side of that, a trademark registration is close to an absolute defense in the context of an infringement action. And so having that registration will minimize or lower your risk of liability. Obviously, from a counterfeiting standpoint, similar to the U.S., registering those trademarks or recording those trademark registrations with customs is key, and educating the customs officers and having local counsel there that's good at that is also key. And then having that manageable enforcement strategy, and manageable is going to fit the client. There are oftentimes more issues to go after than maybe are in a budget, and so you have to figure out what's key to try and protect from a trademark standpoint, and then how to go about enforcing through the various means of doing that, whether it's an opposition or litigation or utilizing some of the local authorities there.
Yep. And so going specifically to the first part, when you identified registering your mark, here under U.S. practice, we have a first-to-use system under U.S. law. So in other words, if you begin using your mark ahead of someone else who is a second user, or even a filer, someone else who files first before you, but you use before them, you have the priority rights based on your use. Does China have the same system?
China is a first to file country, or a registration-based country, and so common law rights, if you will, are not necessarily as key. Although we'll maybe talk about in a minute here, the amendments to the trademark rules do provide some exception now in the future for that. But it makes it very important that, again, going back to the point of, from a strategy standpoint, to register, because it's first to file, registration makes all the more sense in that regard.
And what's the downside if you don't aggressively seek filing a trademark application for a mark you intend on using or are actually using in China first?
You could be precluded from continuing your use. If somebody else comes along and registers subsequent to your use, they're given that exclusive right to use the mark and prevent others from using the mark. So it could be a situation where you've been using for some time, and that use can be enjoined.
In terms of additional tips that you might have for U.S. companies in registering their marks, what other things should they keep in mind that would be different walking into China to receive protection as opposed to just what they do here under normal U.S. practice?
Filing for marks in both English and Chinese characters is a big one. Even if you're not going to use in Chinese characters, whether it's a translation of the English into Chinese characters or a transliteration, I think those are considerations that companies should look at. at times, lots of companies will use both on their packaging, and so it makes sense, obviously, to register both in those instances. But even from a defensive standpoint, using local counsel and having their input as to what might be the common translation of a mark, and then securing that, or the common transliteration of a mark, so that somebody else cannot adopt that. And again, sort of leading back to that first to file issue again.
Yeah.
Oh, go on.
Yeah, I was just going to ask, going to that, you're seeing more and more now a Chinese IP system that's regularly trying to change its laws to harmonize them with the rest of the mainstream countries around the world, and you're seeing that now under Chinese trademark practice. Can you give us an idea of what happened recently with China passing its sweeping legislation reforms under trademark laws that's going to go into effect this coming May of 2014?
There's a number of changes. I think too many to go into in this context now, but a couple of them that I think are notable to U.S. companies are, and this was alluded to earlier, there is sort of a common law right that will now be acceptable or recognized under the amendments to the trademark law, essentially saying that if you've used your mark in China and gained some reputation prior to someone else filing, you should be allowed to continue to use that mark in China in sort of within the original scope. And a lot of these amendments, I think it'll be interesting to see how they're actually interpreted and implemented, because you can imagine a number of scenarios where it might not play out as cleanly as it's written. That's one that I think is a change that U.S. companies should be on the lookout for. Another one is the amended law now recognizes punitive damages in trademark cases. It's not clear to me what the threshold is for punitive damages to apply, or what you would have to establish in court for that to happen. Shen Min may have a better sense of that based on the legislative history there, but I think it's a clear indication that the Chinese authorities and the government want to curb, if they can, or provide mechanisms to curb squatters and folks out there that are clearly trying to piggyback on legitimate brand owners. On the damages side as well, the cap on statutory damages increased from 500,000 yuan to 3 million yuan, which I think is somewhere between going from like 80,000 US to 500,000 US from a cap, which again I think is an indication that they're looking to make the damages more meaningful and curb that type of piggybacking. One thing that's also sort of notable and might help U.S. companies as they plan is there are a number of statutory limits or time limits that are built into the new law for application and administrative procedures. For instance, a new application now has to be examined within 9 months of filing. An appeal to an objection for that application has to be decided within 9 months of that appeal, and their opposition procedures need to be decided within a certain time limit, certain things like that. So I think those are important to U.S. companies going into China or filing in China. There may be others that Shen Min would also like to highlight as well.
Yeah, so I think that the one thing is good news for U.S. company now. It's multiple classes now. One application is doable in China. Used to be one class, one application. So I think that's good news. And the renewal period now extended to before the expiry date within 1 year, 12 months. So you get an extra 6 years, and also your 6 months grounds period is also available. So that's also good news. And for security issues, if you have a business contract with Chinese companies, if you have those kind of the contract. So if your Chinese partner register your trademark, so now it's much easier for you to invalidate or oppose the trademark or invalidate the trademark. So it's stipulated in the law. So it's also I think it's helpful for U.S. company registering trademark or doing business in China.
Yeah, you see that across the board, I think, with these sweeping changes with the trademark reform, is that the idea there is to help level the playing field for non-Chinese entities in China. And that's a common problem, is the last one you raised. I've seen that firsthand, where you have situations where U.S. companies will have a exclusive distributor, some sort of arrangement where they're selling product into China. And you'll have a situation where that distributor will file marks in China for the U.S. entity. And next thing you know, we as attorneys here, we're looking to get marks for our client in China. We do a trademark search, and lo and behold, somebody owns your mark, and what you realize is that it's your distributor. And so that's exactly right. There is actually, and that's part of the change in the law there, is to allow the ability for the true trademark owner to get their rights back. And again, it goes back to a lot of the fairness issues, leveling out that playing field, the concerns, in particular in the U.S., the U.S.-based companies have in doing business in China. Ari, I want to turn now, hearing out all these changes in trademark law, and how does that affect, once a U.S. business has registered such marks in China and is seeking to use them, and quite frankly seeking to stop others from using them improperly, what can U.S. companies do better to make sure that they don't see counterfeits or knockoffs enter the U.S. market while still in China?
When a knockoff of your product lands on your desk and you see an infringing mark of yours in which you've invested millions of dollars and decades worth of research and advertising, and you see that plastered all over the web, your visceral reaction is to go after those copycats. And I'm using the word copycat very lightly, instantaneously. And you want to shut them down quickly and stop sales and advertising. But you have to realize that if you react in that way without kind of vetting out your options, you may be damaging yourself in the long run. And there are a lot of arrows in your quiver, so to speak, with respect to options that you have with Chinese IP law to go after infringers and counterfeiters and copycats. But you have to realize the pros and cons. And I'm all about practicality. So, if you want to go after an entity, you can send out a cease and desist letter. And I don't know about you or your clients, but I haven't had much success in terms of getting responses back. I'm sorry, we'll stop. The risk, the practical risk you run without sending out a cease and desist letter, especially in Chinese jurisdictions, is that you may see the infringer filing a DJ action, a declaratory judgment action. And that can be used really as a sword and shield by these infringers. So if you send out a cease and desist letter and you don't follow up and you're not ready to proceed into litigation, the infringer may institute an action against you, asking the court essentially to issue an order saying they're not infringing. And you have to act quickly in order to prevent that. Other options include working with local administrations of industry and commerce, the AICs, in specialized regions to orchestrate raids so you get that product seized immediately. And Grant touched upon it, Shinmen did as well, in terms of working with customs, and this can be very effective, where you simply register your mark with Chinese customs, you provide them with samples of your products, and then they're on the lookout for infringing products that may be leaving or coming into their country. But you also have to educate them, and I think Grant mentioned this. You can develop relationships, and this is where, I guess, as Confucius says, real knowledge really is knowing the extent of one's ignorance, and where you want to work with outside counsel in developing relationships with customs officials to educate them on your products so that they don't actually seize the products you're making in China. And that's happened on many occasions. And then you have to unwrap that whole mess. So working with customs is very effective. It can work in a number of ways, but of course you have other recourse in the courts with respect to litigation. But of course, once that matter is hopefully resolved in your favor, it's kind of like a game of whack-a-mole. 5 or 10 other entities may have already popped up selling, and then you're back to square one. Cease and desist. Do I go after them with a raid? and then deal with customs again.
Yeah, and ultimately, just like in all other things in life, and in this instance it's true too, prevention is the best form of medicine here. If you can, it sounds like, prevent it at the border, at the customs border, stop it from happening, stop it from entering, for example, the U.S. market or other foreign markets outside of China.
Sure.
Take advantage of that. And like you said, a big part, that's true for any customs matters if you ever work on with customs, is education. You have to educate customs officials, teach them what to be on the lookout for, teach them what your product is, even if it's confidentially marks on your product or even on your logos that differentiates you from the counterfeit. So that's a big part, it sounds like, of this whole policy that you see with U.S. companies doing business in China.
Absolutely.
And to some extent, that's true with the U.S. Customs too, to prevent it from actually entering the U.S. Customs has a very robust program. You can register your trademarks just like the Chinese program and work with them. I mean, you can educate. They actually want to be educated on looking for infringing products. So it's a great opportunity, and it's actually very low cost. And they're looking for that help.
Just to touch on Ari's point, sometimes, unfortunately, you'll receive notices of shipments that are leaving that are authorized, and that's something else that you need to sort of build into your program, where you understand who your authorized distributors or suppliers are, so that you're not spending your time dealing with issues that are, sort of false alarms, if you will.
Sure. And again, that's a great point, a practical one. Keeping control on everything that's being exported, who's exporting it, when's it being exported, and having good records of it that's consistent with what your business is understanding is leaving the country. So along those lines, unfortunately, infringement does happen, and it happens in China as well. Shenmin, how has Chinese litigation changed in the past few years?
It's changed a lot. So first of all, the litigation cases rise dramatically. So I have data here. So last year in 2012, there are over 9,680 patent infringement cases filed before Chinese court. Back to 2008, it's around 4,000. Patent infringement cases, so almost doubled, more than doubled. So that's one thing. So a lot of people actually are worried about the get unfair treatment in China if you file the litigation there. So there's no official data I can show you, but we did a little bit of research. Those cases handled by Chinese court. We actually look at the Chinese court website and collect 3,000 patent infringement cases published on the website. And we found in these 3,000 patent infringement cases, most of them litigations are between Chinese companies. So only 129 cases involving foreign party. So for those 129 cases, 97 cases decided by the court. Some cases just dismissed or dropped. And for these 97 decided cases, 88 cases are between Chinese and foreign party. So, but foreign parties wins over 52 cases. So that's kind of the feelings for Chinese patent attorney now, where we think the government, the court actually are slightly favorable to our foreign parties. So that's the data we did a little bit of research. It's not complete data, but somehow show you the tendency of litigation in China.
Now, in terms of when you think of U.S. litigation, a typical case for us when we seek to enforce, let's say, a U.S. patent against a competitor in the United States here, we file our lawsuit on behalf of a client. We're looking at a typical, from the complaint being filed to trial, being somewhere between 18 and 36 months. We're looking at typically millions of dollars being spent by both sides combined, significant amounts of discovery, expert discovery. preparation for trial, damages analysis, all of those things. How does that compare to Chinese, let's say, patent litigation
There are
specifically?
a lot of difference between Chinese system and the US system. First of all, in China, no discovery procedure for collecting evidence. So it really depends on the plaintiff or defendant to prepare their case. The second, there is no case law in China. So, China, here you can follow the case law, but Supreme People's Court really issued the explanation for patent infringement cases, which can be used as a guideline for local court or lower court to decide the same case. So that's one thing. Another one, in China, there is no jury trial. So the judge, the judge or the panel of the judge, they will decide the case. And also for willful infringement, there is no punitive damage issued by the court. But the new law are amending, maybe the situation will be changed. And another one, the damage in China issued by court is not a big number compared to US system, So far we got the highest damage is 48 million. It's a big number, but a lot of questions regarding this damage calculation. Normally, look over the average highest damage is around a few million, so 1 million, 2 million. So maybe it's not a big number, but if you convert to the Chinese yuan, it's over 10,000, over 10 million yuan. It's a big number in China, but for US company, maybe it's not big enough. And also in China, if you do litigation, you can do a little bit of forum shopping. So that means you can choose the court in in big cities, not in small cities. So the courts in these big cities are, I think they handle a lot of those kind of patent infringement case. The judge are knowledgeable, are experienced, so you can get fair treatment there. And another thing is in China, second instance is final. So that means you file the applications to the court, and you can appeal to the high court, and then the second instance is final. So normally, you stop there, but you can appeal to the Supreme People's Court. It really depends on your case. They may try or not try your case.
I got a question for you in terms of remedies themselves. Under US law, you think of remedies, you think of injunctive relief or monetary relief, like we were just talking about in China. Is it a similar system? What are similarities and differences there along those lines with respect to remedies? What type of remedy options you would have in China that might be similar or even different from US
Yeah,
practice?
so you can, first of all, you can, the damage calculation, there are several different ways. The first one, you can calculate based on the damage, lost for the patentee. If it's not available, you can calculate based on the profit for infringement. And if this is not available, then you can, calculate on the reasonable, times of the license or royalty. Royalty. And the last one, the court will issue the statutory damage, which is 1 million yuan. That's the maximum. Normally, you cannot get that much. Yeah. And also, when you do the damage calculation, the Supreme People's Court actually issued the explanation for calculation based on the apportion part. So that means the infringement profit is calculated based on the infringed patent, not the profit of selling the infringed product.
Here's a question from the audience. What are the proofs necessary to support litigation to prevent further unauthorized use or infringement of that intellectual property? So in other words, what do you have to, in order to establish your burden of proof for infringement, what do you need to prove in a, let's say, a typical patent or even a trademark case?
Yeah, so first of all, you need to be, you have the valid patent IP rights. So the trademark patent rights. So I just want to talk a little bit about the utility model patent and design patent. So if you file the lawsuit involving those two patents, you need to provide the evaluation report to the court made by Chinese patent office. So this report actually conducted the comprehensive analysis assessment of the patentability of the utility model patents.
So you have to provide probably the product itself too, the accused product, the logo.
First of all, validity of your IP rights, and then you need to get the infringing product in the market. So one thing you can do, you just follow the infringer product and purchase the notarized before the notarized the infringing product. Then you can use this as the evidence to pursue the litigation in China.
In fact, go back to the utility model case that you raised, that $53 million case that a Chinese entity won against a French company, and that was on the energy side. What was interesting about that case too, even though there's no discovery, the Chinese entity wins that judgment. Right. There was a little bit of discovery order by that Chinese court there to seek the exact amount of revenues that company had based on this product at issue. So there was technically an order there, and then based off of that, that's how the amount of damages was determined. So you'll see things like that happen too with these in this Chinese litigation with the courts there.
Yeah. So one thing you can do is, actually, you can request the evidence preservation if you file the lawsuit before the court. So you can ask that, and the court may grant your request and preserve those infringement evidence. This is the case actually happened to the Schneider versus Chin the cases. So the court take the action and make the copies of the contract, the sales information, all those things. That's how they calculate the damage for $48 million.
And how about speed? Here in the U.S. you see 18 to 36 months, or even longer, depending on the complexity of a patent or trademark
in China.
litigation.
So one difference also in China for litigation is when you file the lawsuit to the court for infringement case, so the defendant normally will request the invalidation before China Patent Office. So here the court handles all the validity, invalidity issue, but in China it's a separate system. So the defendant filed the request of invalidation before Patent Office, and the case may stay or not stay, depends on the evaluation report, depends on what kind of your patent. For utility design patent, normally judge will stay the case. For invention patents, may not. It really depends on the judge choice. And then the case this is one thing. You handle different system, different requests by different system in China. Turn back to the speed. If there's no invalidation proceeding, normally it takes 6 months to get the first instance decision. If involving the invalidation proceeding, it takes around 18 months. So for appeal, normally it's around 3 months or 4 months. It's much shorter than the first instance.
So much faster than U.S. litigation.
Exactly. Actually, I think the judge, they have a kind of the responsibility to speed the case in China. They are required to decide the case within specific time frame.
I've heard this question before from clients, and it not surprisingly appears here before us today. And here it is. Are you aware of any instances where a non-Chinese entity has successfully enforced a patent within the People's Republic of China? That's something we get a lot, that question. Does it happen? Can you walk in as a U.S. company and enforce your IP rights against a Chinese entity who's infringing you?
Yeah, of course. I have some clients, they did good, did successful enforcement for their IP rights. So what do? You can, if you want to enforce your IP right, first of all, you need to get your IP right well protected. Not just, for patents, you need to get very strong patents and can face the invalidation. So this is very important. Second of all, you you need to find a good patent attorney or lawyer, because those people actually did the work for you. It's not you to do the work. So, so you need to find a good one. And another one is, like I mentioned, you can do some forum shopping if you want to get, fair judgment. You probably need to choose the big city, Beijing, Shanghai city, to file the lawsuit there, and that's doable in China. And another one is, there's not just a lawsuit. You can also use the administrative enforcement. So especially for design or utility model patent, those patents are relatively easy, and you can file the complaints to local office, and those offices actually can take action. The beauty for administrative enforcement is, first of all, it's very quick. Within 4 months you get a decision, and also it's easily enforceable order, because there's no damage issued. So if you want to get money, you still can file a lawsuit to the court. And another one is a simple procedure and much cheaper than the litigation. The final beauty for administrative enforcement is you actually can, it's a good way of obtaining the evidence. It's difficult for you to collect the evidence in China, but if you, enforce your IP right through administrative enforcement, the evidence collected in this during this procedure can be used before the court if you file the damage, request the damage before the Chinese court. So this is another thing, and also don't want just fight with each other. Sometimes the settlement is best for both parties. So the judge actually are willing to settle the case in order to create a harmony society. Yeah, so that's kind of they like to settle the case. So for Schneider case, we mentioned before, the Schneider appealed to the Zhejiang High Court for the damage, 48 million damage. And the High Court actually really, make an effort to try to settle the case. So they hold 50 mediation for both parties, try to settle the damage. So finally, the agreement is reached for both parties. The damage is decreased to half of the damage, 24 million. So there's a lot of options. Of course, the communication is also very important. So even though the communication with the judge is very helpful somehow, if you want to get a good settlement or get a good damage issue, so encourage your attorney or lawyer to communicate with the judge, discuss the case.
One other thing too about that, it was called the Schneider case. That's that $53 million verdict. Another thing that came out of that case was Schneider actually owned patents in Europe. It's a French-based company that was able to assert against them, and that ultimately helped that settlement. That's something, again, for our clients to keep in mind. If we have patent rights, IP rights, we can enforce back against those companies in other jurisdictions. The downside might potentially be that in Chinese litigation, the speed of it could hurt you, but ultimately if it's something that you can use against that competitive entity, that's something to keep in mind, and that's exactly what happened in that case. I have a general question for all of you. This is out of the audience as well. In terms of filing patents or trademarks in China, how does protection extend out into Hong Kong and Macau, those other jurisdictions you think of associated with China? I even put Taiwan in there because it's a very different, I know that, protection there. So does anybody want to raise those, let's say for trademarks there, Grant?
They're not protected. A Chinese registration does not extend to Hong Kong or Macau.
That's right. You have to file separately, plain and simple.
Same with patents. You have to file them separately in those jurisdictions.
In Hong Kong, actually, you can, if you file the application in China, you can just, within 6 months of your patent application publication, or within 6 months from the grant of your patent, Chinese patent application, so you can register the Chinese patent in Hong Kong. So it saves you money and save your time. It's an easy way to do.
One other topic over the last few minutes I'd like to talk about is, with you, Todd, is a specific one called inventor enumeration. So you have a situation, let's say if you're a US-based company, you start doing business directly in China, you're developing, you're doing research and development in China, you have Chinese nationals or Chinese citizens doing this R&D for you, they begin to invent, you put product out in the marketplace. What kind of things should U.S. Companies be thinking about in regards to what we know as Chinese inventor remuneration laws?
So China has a law that states that employers must pay a reasonable reward and remuneration to an inventor employee. Now they actually have statutory requirements here in terms of how much they need to be paid. But there's also an exception that says that you can enter into an agreement to pay them, but it still has to be reasonable. So that's the big debate, is what is reasonable. I would say, for sort of general rule of thumb, is that whatever the statute says, that's what they consider to be reasonable. There may be some other opportunities, reasons why you would be higher or lower, but it's something that you want to evaluate and look at to make sure that you are actually paying the employee. And the other part to this too, it doesn't have to be cash. It can be stock. It can be other sort of benefits that they get in addition to just cash. So you need to look at that, and especially if you're having any research and development done in China, you want to make sure that you've got a policy and procedure in place so that you're not necessarily relying upon what the statutory requirements are. Because the biggest downside of this is by statute, there is if you receive a royalty as a company on a patent, that inventor gets 10% of that royalty. So that's a pretty significant chunk of potential money for the inventor. So to avoid those situations, you may want to think about developing a good, strong policy in China to remunerate your Chinese inventors.
If I may jump in, the end result too is if you don't have a good policy in place, is that you may actually jeopardize the validity of a patent or ownership rights.
Right.
So the inventor who wasn't properly remunerated may actually be considered an owner of that patent, and they can license it to whomever they want, just like their company can license it to whomever they want. It can get very messy very quickly.
Absolutely, and you will see if it's an employee, it's very possible may end up with your competitor.
And the proposed change under Chinese law right now, I think, is going from, with the statutory level for inventor remuneration right now is about 0.5%, and it's the proposal is to bring it up to about 3%. So if you don't agree or negotiate out with your employees what that amount will be, the Chinese government will set that rate for you, and you might not like it. So something to keep in mind there as well. Another question, actually got two of the same questions here. So here we go. Does enforcement or the granting of patent rights, and I think they do mean enforcement in this question, does the enforcement of patent rights depend on which province you file? In other words, and I think I know where this question is going, in other words, you have an infringer, let's say, that operates in a number of provinces throughout China. Do you have to seek a lawsuit against that infringer in each of those provinces? Can you do it in just one, and will that judgment be entered into the other provinces?
You can do just one, and the decision issued can for same infringer. So for one infringer, you can just pick up one province or the city to do the litigation or to file the complaint to the local office, and the decision will apply to all the different cities.
So, and those are all the questions that we have at this point. We're about to wrap up here. So a couple take-home points I think that's important that we learned out of today's discussion. I think on the patent side, utility model patents, if you don't know about them or haven't looked at them closely, is something you should seriously consider as part of your overall Chinese IP strategy for your clients. I think that's a very important one. As you can tell, they have a lot of teeth. They're a lot quick. You can obtain them much more quickly, and you could potentially utilize them as a strong enforcement mechanism. The other big one that kind of encompasses this whole discussion is fairness. There's obviously a viewpoint with US-based companies of a level of unfairness in either obtaining patent rights, trademark rights in China, or enforcing them for that matter. As you can tell, a lot of the changes, I think, with the laws has changed that in China. But also, I think, the way I look at it is, it's not so much from a fairness or unfairness perspective. It's not surprisingly just a very different set of rules in China than what we have under US practice. And I think a lot of practitioners and companies in the US have an expectation that based on their knowledge, experience, and expertise here in the US, similar analysis and outcomes should happen in China. And a lot of times it's just not the case based on the statutes or culture or some other things there. I don't necessarily think it's a fairness issue per se. So it's something for you to keep in mind, is understanding that, understanding the rules, so to speak, and getting good Chinese counsel involved every step of the way to help identify options that you have. And the earlier you prepare and the better you prepare, you avoid a lot of those issues. And I'll take this is sort of a take-home point for me in regards to statistics. This one jumped out at me. I read this one recently a few months ago, and actually talked about this one at a CLE I gave recently as well. In terms of R&D dollars and the filing of patent applications per $1 million spent on R&D, China's become #1 in the world in that. So think about that. You see about 4 patent applications filed in a company for every $1 million they spend in R&D, and that surpassed even Japan and South Korea, which has always been #1, #2 in the world in that statistic. That's a huge statistic when you think about it. To give you a level of comparison, US-based companies are 19th in the world at that number. It's about 1.9 applications filed for every $1 million in R&D spend. So again, there's a very aggressive strategy being taken on by Chinese companies for various reasons that we talked about here in seeking and obtaining protections for their IP rights. So with that, I want to thank each and every one of you very much for your time today. If you have any follow-up questions, please reach out to any one of us. We'll be more than happy to answer them. Thanks again.
Merci.